Good day, banking law student. I am Michelle Kukamur. I am one of your lecturers for Banking Law 2, which forms part of your LLM in Banking Law. Today's lecture is not going to be a detailed lecture, as you know, you're LLM students, so we do not provide you with a detailed content analysis. It is just a bit of an introduction to the law relating to credit cards and also a discussion of some of the sources which are prescribed. On the slide before you will see the prescribed material for the lecture today. Now I've made some notes concerning the Jones source. Some of the aspects relate to UK legislation and you can ignore that specific aspects. The same would also apply to the Brindle and Cox textbook. There's specific sections relating to the UK legislation which we will not necessarily ask, and you can read that for a bit of background knowledge. Then relating to the articles written by Stassen, mostly relate to the relationship that would exist amongst specific parties to the credit card transaction, and I will make reference to that a bit later on specific aspects that you can go and find answers for in the Stassen articles. Then I also refer you to specific case law. The Diners Club case is of specific relevance to you, and if I may then give you a bit of guidance, read the Diners Club case once for yourself, but then go and read the Schulze article explaining the exact nature of the legal issues raised in the Diners Club case. And then obviously we will conclude with mention of the Van der Bijl article, which you can go and read for yourself. Now, when we talk about credit cards, we talk about a credit card providing a revolving line of credit, where your consumer would use a card to pay for goods or services, and then they would have to make a monthly repayment to your card issuer of the amount that's due. Now you can go and read paragraph 2 of the Schulze article, which I've already mentioned, for a broad discussion also on the nature of credit cards. You can also see that Schulze provides you with 4 functions of a credit card, so please go and read that at your own time. Now you basically get 2 types of credit cards. Firstly, you would have a two-party credit card, where obviously, as the name says, you would have an issuer of the card and you would have the card holder. Now in a South African context, it would be, for example, if you have a store card, a Woolies card, where you would buy food or clothes on credit from Woolworths, and then you would be sent an account from Woolworths to pay a specific amount at the end of the month. The other type of card, which most of us actually do have, would be a free-party credit card. So that would be your bank card. So in our South African context, again, if you have Absa credit card, a Standard Bank credit card, Discovery Bank credit card, you would have your client, which would be your card holder, me and you. You would have the supplier of the goods and services, and then you would have your card issuer, which usually would be a bank, but until Discovery had their separate banking license, it was also Discovery, for example. So you would have then, as the name say, free parties to the specific credit card. Now this is a bit of a very busy diagram to give you a bit of an indication of how these relationships work. Now firstly, you would have your card issuer and your card holder relationship. This relationship gives specific obligations and rights to the holder and the issuer, and you can find what those obligations and rights are by reading the credit agreement. Now, an open question then is whether the standard agreement provides that the payment must be absolute or conditional. And here I'm referring to the Diners Club case and also the discussion in Schulze concerning the nature of the payment made by credit or using a credit card. Now, aspects that you can also then consider there would be the mention in the Diners Club case about specific contractual terms potentially being contra bonis mores, and then this would be in a case where a term is found to be unfair in an agreement, but in our case specifically this credit agreement related to the credit card. Now, just on a side note to mention that in this module, Banking Law 2, we don't necessarily discuss the National Credit Act, but where you have an individual, which would be the card holder, obviously it would also amount to a credit facility, which would be subject to the provisions of the National Credit Act. So just keep that in mind also, that we assume that because you are also enrolled for Banking Law 1, that you know what a credit facility would be. Now, what we also then want to make you aware of would be the relationship that would exist between your card issuer and then your supplier of the services and goods. Now, that relationship is also regulated by an agreement, namely the supplier agreement. And as I've mentioned, there's not really naturalia that exists for this type of contract. It also doesn't qualify as a stipulation on behalf of a third party, which would be your card holder. In this regard, I refer you to the Stassen article to familiarize yourself with the legal relevance of the offer being made to accept payment with credit cards and what the legal nature of that offer would be. Now, obviously, there must be a relationship as well that exists between your card holder and the supplier of the goods. Now, important questions here would be, what happens if my issuer decides not to pay the supplier for the goods and services the card holder acquired? Now, the general rule is the suspension of the card holder's liability ceases and the card holder would become directly liable to the supplier in this case. But then a more complicated question: what then happens if your card issuer already paid, your card holder already paid the card issuer for the outstanding amount that was that occurred as a result of the card holder buying goods or services on credit? Now, luckily, this question will be answered in the Charge Card Services Limited case, and we refer you to the specific case and then also mention of that in the Stassen article. In essence, this would also then relate to the question of when ownership would pass to the cardholder of the goods or services bought using a credit card. Considering the general principle that goods and services bought on credit passes to the person which made the acquisition when the goods are delivered to that specific person. Now, please see then whether this rule would also then apply in case of goods purchased using a credit card, and how this would be different if we had a cash transaction. So to recap, you have different relationships on a credit card. Each relationship brings about a specific legal obligation on the different parties involved. That legal obligation depends on mostly the contract concluded between those parties, and then you have to consider whether terms included in that specific contract could be unfair. In that case, you need to familiarize yourself with the effect of that, i.e. whether this actually then makes that specific contract or provisions of that contract invalid. Now I'm just quickly going to run through some of the discussions that form part of one of your sources, namely the Jones source. And here it related to the extent of the liability for the different types of transactions, so that you can just see that everything links back to the legal relationships between the parties to the credit card. Now, firstly, we talked about transactions entered into by the debtor, then a transaction entered into by an agent of the debtor where that specific person was an authorized agent, but the transaction was unauthorized. And then what happens when we have an unauthorized user? You have to consider in all of these instances what the liability of the debtor would be. And in most of the cases, you will see from reading your material that this would then depend on some principles of the law of agency, but in most of the cases as well on the provisions of the agreement entered into between your credit card holder and your issuer. Now you see here the heading refers to liability of the debtor. Now remember for yourself that in essence the relationship between your card holder and your card issuer would be one of debtor and creditor, where the creditor agrees to advance a certain revolving line of credit to the debtor for the purchase of goods or services up to a specified limit, and the card holder then agrees that a specific amount would be repaid back to your credit card issuer. Obviously having interest component and perhaps also some fees involved in that. Now, if we have your transactions entered into by your debtor, I've already mentioned to you that most credit card agreements provide that the debtor would be liable for amounts entered on the account between the debtor and the creditor. Now, unfortunately, a credit card agreement might contain onerous payment obligations. For example, the debtor can be asked to be indemnify the creditor for any loss that the creditor may have as a result from the debtor or even an unauthorized person using the card. Now, obviously, in your questions and in your further reading, you have to go and consider then to what an extent this would be a reasonable contractual term, or as we've also mentioned to you in the Diners Club case, where they refer to whether a specific term would be contra bonis mores due to the term being unfair. Now, obviously, when I talk about authorized transactions, you would know that an agent enters into transactions on behalf of the principal, in this case, our card holder, for example. Now, the actions of the agent is regarded in law also then as the actions of the debtor. And this then also brings us to our next discussion of the material in Jones. Now, for which actions would the debtor be liable for? Now, obviously, the first answer would be the debtor would be liable for the acts of the agents within the scope of the agent's authority. Now, the question then would be, would the debtor in any instance be liable for unauthorized acts of the agent? The first example I mentioned, what if an agent goes outside the mandate agreement they had with the principal debtor? Now think to yourself, the agreement exists between the debtor and its agent, or the principal and his agent rather. Your creditor, in this case our card issuer, does not have knowledge of that mandate agreement. So can you be bound by an agreement to which you are not a party to? What then if your agent breaches the terms of the credit agreement? So this is the agreement that was signed between your card issuer and your card holder. Obviously, you would have a claim against the agent, but with the debtor, be liable in this regard. Then, what would happen with the liability to your supplier? Let's say you have an agent now, which goes outside of the mandate agreement you signed with the principal. Now think to yourself whether, in practical terms, a supplier of goods and services would have knowledge of the content of that mandate agreement that was signed. Probably not. So what would be the liability in this case of the debtor towards the supplier? These are all questions that you need to consider, especially when you prepare for the exams, but also then with a view of being able to answer this as part of a factual scenario as well. It all goes back to the explanation that I had earlier in this presentation concerning the different legal relationships that exist on a credit card. What I would advise would be to see whether you can't draw a little diagram for yourself, as I did in a previous slide, to bring in all the different elements of the legal relationships that exist between the different parties to a credit card, so that you can see how all of this, or all of the principles in the different sources, are integrated. You would have seen that the part dealing with the liability of the debtor, as discussed in Jones, pages 183 to 186, is not necessarily South African specific, and it might not be relevant at this stage anymore. Therefore, you can read through it for your own interest, but you are not expected to know this knowledge in detail. We would rather prefer that you consult the articles written by South African authors, which would be your Stassen and Schulze, in order to provide yourself with a general understanding of the liability of the different parties to a credit card under South African law. Now, the next aspect discussed in Jones relates to the liability for use by an unauthorized person. And as you would now have seen, something that repeats quite often relates to the terms of the credit agreement which was signed, having an influence on the liability of the different parties. Now, obviously you would have in your studies come across the bank-customer relationship, and you would have known or read as well that some aspects of the bank-customer relationship would also then influence the provisions of the credit card agreements which were signed. The bank would have a duty of care towards your client. Now, I've mentioned to you before that you can exclude a detailed discussion of the references to the UK legislation, and I just make mention of this on this slide again for you. Now, importantly, one of the general principles that you would have would be that the liability of your debtor for unauthorized transactions would stop from the moment that they inform the bank, or more generally the card issuer, that a card has been lost or stolen. From that moment on, the liability of your debtor would stop. And in this case, where a creditor becomes liable for the transaction then, from that point on. And there might be an instance where a supplier was negligent. They would also then have a claim against a supplier if they could satisfy the requirements to prove their claim, either based on the contract which they've signed with the supplier, but also then relying on the law of delict. Now, you would have mentioned, or it would have been mentioned in Jones, the reference to the law of tort. In South Africa, we refer to the law of delict. But obviously, whether there is a specific claim would, in that instance, depend on the specific circumstances of that transaction. You will notice also in the prescribed reading in Jones that there's a discussion on the relevance of a signature to the specific transaction, and you've also have seen probably some references in the other prescribed reading material. Please familiarize yourself with the effect of a signature on, for example, say the payment slip or on the back of the credit card in terms of the liability of a specific person. When we move to the liability of the creditor, we obviously refer to the liability of your card issuer in this instance. Again, in Jones, there's reference to sections of the Consumer Credit Act, not the South African legislation. And again, as mentioned before, this is just for additional reading for yourself. It doesn't relate to the South African context. Now, I've already mentioned to you before that the relationship would be one of debtor and creditor. Just recapping, so obviously the debtor has an obligation to pay the debt obligation which they incurred as a result of using the credit card, and the creditor then lends the amount to the debtor to purchase goods and services up to a specified limit. As I've mentioned before, this would be a revolving line of credit. Again, as I've mentioned, you can ignore paragraphs 5 to 15 of the prescribed reading in Jones. Now, the Diners Club case is very relevant to you. What I would do if I were you, I would have a good read of the article by Schulze, but I would then also have a read through the Diners Club case itself. Now, the important aspect that Schulze raises relates to the legality of the credit card agreement. So, obviously, remember, as we've mentioned so many times, the legal relationship between your issuer and holder is regulated by the agreement. So, if your card holder wants to escape liability, obviously, they would question the validity of contractual provisions. To do this, they would have to prove that specific provisions would be contra bonis mores and with effect then being invalid. Now, a contractual term, as I've mentioned probably before, that would be against public policy, would, for example, be if a specific contractual term is unfair. So in the Diners Club case, this was exactly what the holder of the card attempted to prove. Very interesting, in this case, you will see there's also mention of the Electronic Communications and Transactions Act and how that would apply to credit cards. So also have a look there and see whether you agree with Schulze's conclusion on whether, if this case would have come through or appeared against or before a different judge, it might have had a different outcome. This was a very short lecture. Obviously, as I've mentioned before, you are an LLM student, and it is important for us to just give you a broad guideline on what you should study. This is obviously the first lecture dealing with credit cards. There will be more to follow, so please keep an eye out in this space for further lectures. You are also welcome to contact any of your lecturers as indicated in your tutorial letter 101. All of the best with your studies.